Welcome back. My name is Patrick Noland. I am an attorney licensed in the state of Missouri. This is Pat Talks Law. You know, there are some interesting things happening in Missouri law right now. For those of you who have been following Missouri's medical marijuana rollout and the problems inherent with that, you'll be aware that the license applicants that were denied, a number of those applicants have sued. More than 800 sued. There are still more than 750 cases pending. And one of the items that was challenged was release of information regarding the scoring matrices and the answers. The DHSS had argued that that was confidential information and they weren't going to share it, even though that information is critical to determining whether or not the state authorized and used an arbitrary and capricious scoring mechanism, or even worse, one with code words to identify the winning applicants. So that was argued and the state lost, was ordered to turn over those documents. They appealed and they lost, and they were ordered to turn over those documents. And then they requested transfer to the Missouri Supreme Court and it was denied. So as it stands right now, DHSS has to turn over that information in discovery. Now, that will of course be subject to what we call protective order, meaning the attorneys that receive that information will not be allowed to share it. They can't publish it, they can't transmit it, they can only use it in their case. And you know, that even goes as far as to presume that that attorney would not be able to use it in another case in his office. So while they might be aware of it, you still have to parse that out and request it separately in the other case. In that case, what happens now is they've got to make decisions, and frankly, I haven't seen that data set. I can't say what is in that data set, not with the certainty that you would expect from an attorney. However, I can say that it is my opinion that that data set is going to show that the people who have accused DHSS of a flawed scoring process are going to find vindication in those numbers. I believe that's the case, but it's not by any means a proven fact yet. So then the debate, and if you're following the forums and you're following the discussions, you will have seen this. The debate is what happens now. Does the department issue additional licenses to the entities that win their case? Out of the 760 some odd that are remaining, if those people win their case, and let's say 150 of them do, then is the department supposed to issue an additional license to 150 of those applicants? If they do, doesn't that blow the regulatory scheme out of the water? Because constitutionally, they're supposed to have a minimum of 24 licenses per district. However, there are congressional districts that don't have 24 licenses. They're currently active. They can't transfer a licensee from St. Louis County to Adair County. That's not going to happen. So, and the value of a license in St. Louis County versus the value of a license in Adair County is going to be completely different. They are capped at the number of cultivation facilities, but there is no upper limit for dispensaries. So, do they then deem that it's in the interest of the program to expand the number of licensees? Well, and can they? I don't know if they even can. Do they then go back to the cultivation facilities and look at the ones that haven't started progress and yank their license because they violated the regs by not completing the development and getting a approved inspection within 1 year of the issuing of the conditional license? Well, maybe they should. But then what does that do for all the other people who want to apply for a license, and now there's a glut of licenses? Are they going to be for sale? Can they be sold? Or if the number of licenses is now over the limit because of this court action, does that mean that a license cannot be sold, cannot be transferred? It must just extinguish. We don't know. We don't know what's going to happen with that yet. That is one of the things that is just up in the air. Now, this is a distinction between the business of medical marijuana and the consumer of medical marijuana. Does the consumer really care about that? Probably not. All they really want to do is make sure that there's medical marijuana in the dispensaries at a reasonable price, which as of yet there has not. So, on the consumer side, they're facing challenges in regards to home cultivation. Now, again, those of you who are following the social media leaders in these areas are aware of one who's pointing out that, people are being arrested and charged with manufacturing and claiming that they had a license, they had a medical card, and they had a cultivation license. Well, we don't know that because that information is sketchy. All the information isn't out there. I would strongly advise whomever that is not to put all that information out publicly if I was their attorney. So I would hope that they're not going to do that and they're going to get counsel. However, you see these things on Facebook and they're asking random strangers to help write motions. That is so horribly dangerous. If you are in court and your life and liberty is in jeopardy, get an attorney. It's worth the expense. Even a mediocre attorney is worth the expense. So, what does that mean? Where do you go? Well, for patients, there's not a lot of place. Look, attorneys are expensive. That's a given. That's the cost of playing in the legal field. You have to hire attorneys. Now, there are a number of us that take a lot of cases on a marginal fee structure. I have been known to take cases pro bono. I typically average between 100 and 200 hours of pro bono casework a year. And no, I've never claimed that with the bar. I don't do it for accolades. I don't do it because I want to get the awards and that. I do it because those are people that have a genuine legal need. I've evaluated, and they're people that need help. They're getting screwed. And I don't do it for everybody. It's actually very rare. Probably 60% of my current, even more than that, I'd say 75% of my current pro bono cases that we're handling in my firm, and not just me, but my firm, is all disabled veterans. We're helping them out as best I can. Why? I'm a veteran. I'm helping out my brothers and sisters. That's important to me. And if I'm going to labor for free, or I'm going to pay somebody to labor for free, then by God, it's going to be for something that's important to me. Now, that doesn't mean that somebody's case, 200 miles away doesn't have merit, or 100 miles away doesn't have merit. Their case may well have merit. but you can't ask an attorney to take days off to go work for free, which you can't do it. Got student loans to pay, got mortgage to pay, got rent to pay, I've got salaries to pay, I've got employment tax to pay, workman's comp to pay, utilities, internet, bar dues, malpractice insurance. For even a small firm like ours with 4 staff members, 2 attorneys, our overhead is in the 5 figures every month. So when you hear the people talking about the blood-sucking lawyers, that's just the reality of the business, man. I personally pay more money a month in overhead costs than a fair number of people make a year. And it's horrible. That's why it costs what it costs. An obligation as an employer is to take care of your employees. I like to think that I do a fairly good job of that. I value my employees. We treat them well. And every time they raise the minimum wage, if I don't raise my employee's salary, they're taking an effective pay cut in comparison to inflation. So I have to raise my employee's salary, which raises my cost. It raises my fixed costs. It raises my employment tax. It raises my workman's comp. It raises everything across the board. So the essence of that is if you are in a legal fight, you need an attorney. And if all you have is an attorney that isn't charging a going rate, that is undervalued, you might want to wonder why that attorney has that much time. Believe me, there's enough business to keep us all slammed. Especially right now, coming out of COVID. I have an average of 2 trials a week for the next 3 months. It's ridiculous. So where are we going with medical marijuana in Missouri and with any of the legalization proposals? I gotta tell you, I don't like a lot of legalization proposals because they weaken the medical marijuana as well. I think that anything that does not include an expungement section is flawed. The reason you need expungement is, why are we keeping people locked up for marijuana when we're legalizing it? Why are we keeping somebody in jail for marijuana, for selling marijuana, when we're now going to license people to sell marijuana on every street corner? It doesn't make any sense. It's kind of like Chris Rock. I love Chris Rock, but his routine. The government is broke and desperate, so the government has now approved selling marijuana because medical marijuana, because that's what you do when you're broke and desperate. You sell drugs. Chris Rock was funnier. So another interesting case that has come down deals with the state ownership. Now, this is one that's been glossed over by most of the people that have dealt with medical marijuana issues, and it's 1432, so something to remember for that when I put it in the notes. But with the limitations to 51% in-state ownership, that has been struck down. Okay? You're going to see out-of-state money flow into Missouri's medical marijuana, and full legalization when we do it very hard. Okay? The idea that a small Missouri business is going to be able to make it is probably going to fall by the wayside, because we have a situation where it is now wide open. And when this passed, it's something I talked about back in 2019. Okay? The Dormant Commerce Clause prohibited the state from barring non-state citizens from owning a business in Missouri. It's not legal. It wasn't legal then. It's not legal now. And now we have a court decision saying so. So you're going to see more of an influx from the out-of-state businesses. And you might see an end to this fiction that a business only has X number of licenses. And they're going to start being honest about it. You know, I'm certain that we've all seen the Cannabis Consumers Coalition's report that has said that, you know, one cannabis entity is claiming that they have 13 affiliated dispensaries in Missouri. Well, they can't have 13 licenses, so where'd that come from? That's from the fiction that they aren't all out-of-state owned. You're going to see that more honesty there. So that is probably the second biggest court decision regarding medical marijuana that has come down, aside from the one I talked about earlier regarding the release of information and discovery. So that is something that we will do more on. I'm at 17 minutes. It's already far too long. Please hit like, subscribe. I'll be talking to you again soon. Thanks.